Okay, today's good person to know is Andrew Reith. He's the Business Events Manager at the Intellectual Property Office, the IP office. And he talks about safeguarding your property, your business property, not where you reside, but your trade secrets, your inventions, your ideas, your trademarks. All of these are very applicable to you if you have your business or an idea, because you don't want someone to copy it. So Andrew talks through the different processes that you can go through, how much they cost, the duration, and he gives a fantastic example of Branson's, which was sold by Premier Foods for £93 million. £3 million of that was towards its factories and various other things, physical assets, but 90 million was due to the branding, the reputation, and that just shows you how important a brand is. So if you are thinking about starting a business or have started a business but don't know about the various rights that you have, I very much hope that you'll find this video interesting and enlightening for you. So thank you for watching.
Branson brand, which was sold by Premier Foods in 2012 for an amount of £93 million. In the article discussing it, it was said to include the factory in Bury St Edmunds, which was valued at £3 million. So with a building of £3 million, the stock is not worth much because it's perishable. So where has the other £90 million come from? All about the name, Branston. It's instantly recognisable. People wanted to see it, whether it be on condiments, sauces, pickles, or whatever else. They want that brand, they want that name. If you're looking to franchise out, one of the key things that people are going to be buying into is your name and your reputation. Because we're a government office, all of our help and advice is free of charge. You may need to pay to register, but the information that we give is completely free. To help us with this, we've launched a new toolkit called IP for Business. There's 5 main things. IP Equip, which is an hour's course you can go and do online, completely free. You learn a bit about IP, answer some questions, and at the end you get a certificate and some great links to find out more helpful information. Intellectual property is not one thing. It's actually a bundle of different rights. If you are looking at starting a business, you've got a great business idea, if you are speaking to someone about it, put a confidentiality or non-disclosure agreement in place. Okay, so a trademark is any visual representation of your company or your brand that can separate you from your competitor. Therefore, it can't just be solely descriptive of what you do, your name and your logo. They're the most common things which are registered. However, you can do lots of other things. Domain names. DIY.com, for instance, which is owned by B&Q. Slogans. Every little helps, just do it, exceedingly good cakes. Now, we don't look to endorse any particular company or brand as we're government, but these things all have certain things in common. They're bright, they're eye-catching, they grab your attention, but they say absolutely nothing about the goods and services in which they offer. Think about your businesses. At this moment in time, you might be in one industry. In 5-10 years' time, you might want to expand out and do more. Can your name transfer with you? You're probably thinking a trademark's going to be really expensive. It's not. It starts with just £170 here in the UK. That covers you for one industry, one area of goods and service, one classification. It will take around 4 to 6 months to be granted, but if it is, it will last for 10 years. That's starting from £17 per year. It is a national trademark though, so it's protected here in the UK. If you want to go further afield, there are 3 routes. So you've got the Paris Convention to go to any country that you want to get protection in. There's the Office for Harmonisation in the internal market, who will give you a community trademark, or a European-wide one, for €900. Finally, the Madrid Protocol, which is an international application. No worldwide trademark. Trademark can last indefinitely. If you carry on trading, every 10 years you can just renew it. Just pay the extra fee again, and it will carry on and on and on. Copyright protects written, artistic and creative works. So all of these kind of things can be protected. The most common ones you're probably looking at franchise are manuals, databases, advertising, promotional literature, potentially adverts, so films, music, computer software. Computer software is a literary code, it is a written works. Therefore, it comes under copyright and not patentable, as most people tend to think. The great thing about copyright is it's free and automatic. So as soon as you've created something, it is protected. What you would have to do though, if there was an infringement, is to take legal action yourself. You would have to prove when you had the work and the fact that you were the creator. The best way to do that is still the old-fashioned route. Pop the work into an envelope, post it to yourself, record your special delivery, and if you can, then file it with a bank, accountant, solicitor, some sort of responsible third party. This proves the work was created by you, placed in that envelope with that date stamp on it, and then passed out of your hands, so you haven't tampered with it. Copyright can last for a pretty long time. It actually lasts for literary, musical, and artistic works 70 years after the death of the creator. I can pass it on to my next of kin, to my business, to my cat or dog if I want to. It's a property I can transfer it where I like. For films, 70 years after the death of the last of those people, as there's so many layers of copyright. TV and radio broadcasters cover 50 years. With copyright, it's usually the first author or creator that owns it. However, if I am employed, and I'm basically creating something as part of my ordinary course of employment, my employer owns it. So when it comes to a third party, so if you paid somebody or you've got a friend to create your logo, your website or marketing material, it is that first person who created it that owns it, unless there is a specific contract to say otherwise. So if I've got my business, I can't create a logo, so I come to you, I pay you £500, I get my logo, you still own it, not me, even though I paid my fee. What you have to do is get a contract in place to say the rights are transferring from the creator to the person who's paid it. If you don't have that specific written contract, it just will not transfer. Two main types of infringement. First of all, primary. So if you're doing any of these without the consent of the owner, it is an infringement. So if you're copying, reproducing, adapting, it's an offence. Secondary infringement. With these, you're only guilty if you've done so knowingly. The most common one there is possession for business purposes. So if you've got a business, you've got an IT department that's bringing in dodgy copies of Windows, Microsoft are going to find out about that. And are they going to go after your lonely IT guy? Or are they going to come after you and your business where the money is? There are a certain amount of things that you can do with copyright though, under some permitted acts called fair use. Patents protect inventions and industrial processes. What a patent basically is an agreement between the state and the inventor, whereby we say, we're going to give you exclusive rights to your invention for a maximum period of 20 years. What we want in return is money and a full technical description. So anybody can come along after your patent has expired and recreate that technology. It will take 2 to 4.5 years to be granted, and it will cost you, if you apply directly, £230. But however, we wouldn't recommend you do that. We would recommend that you speak to a patent attorney. They will charge you £2,000 to £5,000, but they are well worth it in the long run.
I just really want to know, what could one do if they wanted to register a trademark or a logo, whatever, and not having to pay anyone? What's the best way they can do that?
If you want to apply directly, you can do so through our website. It starts from just £170 if you chose to do that route. The best thing you can do is go onto our website, ipo.gov.uk. From there, click on trademarks down the left. There's a section on that trademarks there. Click on before you apply, and then how to apply. That will be the best place to start. So it will give you a number of links, including our criteria, where you can do searches, and then looking about other things as well. So that's your best place to start. And of course you can apply directly yourself. However, what I would say is a patent or trademark attorney will give you help and advice. We won't be able to get directly through ourselves, as we are the register. We can't give you opinions, we can't help you too much with the classifications and such, but we will give you as much advice and help as we possibly can.